Dutch nationality law is based primarily on the principle of jus sanguinis and is governed by the Kingdom Act on the Netherlands nationality. Thus, citizenship is conferred primarily by birth to a Dutch parent, irrespective of place of birth. Children born in the Netherlands to two foreign parents do not acquire Dutch citizenship at birth, unless special criteria are met. Despite the existence of 4 different countries in the Kingdom of the Netherlands, only one category of citizen is distinguished in Dutch nationality law. The Kingdom Act on the Netherlands nationality was significantly amended with effect from 1 April 2003. Acquisition of citizenship by descent or automatic acquisition of Dutch nationality. A person born on or after 1 January 1985 to a Dutch father or mother is automatically a Dutch subject at birth. It is irrelevant where the child is born. A child born to an unmarried Dutch father and a non-Dutch mother must be acknowledged by the Dutch father before birth, in order for the child to be a Dutch subject at birth. Before 1 April 2003, an acknowledgement could be given after birth. Since then, children who were not acknowledged before birth may nonetheless acquire Dutch citizenship through the option procedure, or through obtaining proof of paternity from a court. In the last case, the child gets Dutch nationality retroactively since the child's birth. For 1 January 1985, the Kingdom Act on the Netherlands nationality permits children of either a Dutch father or mother to receive Dutch nationality by descent. Prior to that date, Dutch nationality law did not permit children to obtain Dutch nationality through descent from a Dutch mother and a non-Dutch father. Netherlands nationality was only passed through patrilineal descent, only if the father was not known or acknowledged. Did a child born to a Dutch mother receive Dutch nationality prior to 1 January 1985? Between 1 January 1985 and 31 December 1987, children born after 1 January 1964 but before 1 January 1985 of a Dutch mother and non-Dutch father and who had never been married could use the option procedure to acquire Dutch nationality. This possibility was not widely known, and many in this situation missed the temporary opportunity to register themselves of the children as Dutch subjects. In 2004, a number of these children of Dutch mothers and non-Dutch fathers began to organize themselves in the hope of persuading the Dutch government that Article 27 of Rijkswet op het Nederlanderschap condones the discrimination against women enshrined in the earlier Dutch nationality law, and it should therefore be revoked. In 2005, several Dutch lawyers agreed to take on the case and formalized the group into Stichting Nederlanderschap. The legislative change was discussed by Parliament in 2006, but then stalled when the government fell and the bill was withdrawn. In December 2008, a new proposal was presented to the Dutch Lower House of Parliament, and in January 2010 Legislative Bill 31.831 passed a majority vote amending the Kingdom Act on the Netherlands nationality to allow the so-called latent Dutch to opt to receive Dutch nationality, regardless of the current age and marital status, and without requirement to renounce their original nationality. In June 2010, the Dutch Upper House approved the legislation. It was signed into law in July 2010 by Minister of Justice Mr. Hirschballen and H.M. the Queen, and published in the Official Gazette issued by the Dutch government, with effect 1 October 2010. Latent Dutch now have the opportunity to receive Dutch nationality by option. Many latent Dutch regard themselves as having been Dutch since birth. However, while latent Dutch are by definition descended from a Dutch mother, nationality granted through the option procedure is not retroactive to the date of the birth. Under the law, these individuals are not considered to be Dutch since birth, but rather illegally Dutch by option from the date that the requirements of the option procedure are fulfilled. By option, the option procedure is a simpler and quicker way of acquiring Dutch citizenship compared to naturalization. In effect, it is a form of simplified naturalization. In order to be eligible for the option procedure, it is necessary to hold a Dutch residence permit and to be any of the following: an adult who was born in the Netherlands, Aruba, Curaçao, Sint Maarten, and who has lived in any of these places continuously since birth; a person born in the Netherlands, Aruba, Curaçao, Sint Maarten, who has lived in any of these places for an uninterrupted period of at least 3 years and who has not acquired the citizenship of any other country; an adult who has been legally resident in the Netherlands, Aruba, Curaçao, Sint Maarten since he or she was 4 years old; an adult who used to be a Dutch subject and who has been legally resident in the Netherlands, Aruba, Curaçao, Sint Maarten for at least 1 year and whose residence is without any restriction as to length; someone who has been married to a Dutch subject for at least 3 years and who has been legally resident in the Netherlands, Aruba, Curaçao, Sint Maarten for an uninterrupted period of at least 15 years; someone aged 65 years or over and who has been legally resident in the Netherlands, Aruba, Curaçao, Sint Maarten for an uninterrupted period of at least 15 years; a minor who is acknowledged by a Dutch subject who has been cared for and brought up by this Dutch subject for an uninterrupted period of at least 3 years; a minor who, as a result of a court decision or by law at the time of your birth, is under the joint custody of a non-Dutch parent and another person who is a Dutch subject and who, since the start of this custody, has been cared for and brought up by this Dutch subject for a period of at least 3 years during which the child has had his or her principal place of residence in the Netherlands. Exception. Legislation 31.813, inter alia, amends the Kingdom of the Netherlands nationality law to allow latent Dutch to opt to receive Dutch nationality, effective 1 October 2010. The conditions of eligibility through the option procedure differ somewhat from those described above. Eligibility criteria for Dutch nationality as a latent Dutch person of that the applicant was born before 1 January 1985. Mother was a Dutch national when the applicant was born. Father was not a Dutch national when the applicant was born. Applicant did not obtain Dutch nationality between 1 January 1985 and 31 December 1987 through the option procedure and then subsequently lose that Dutch nationality, and applicant has no criminal record. All 5 conditions must be met. If one or more of the conditions are not met, the person is ineligible for nationality by this particular means under the recent changes to the option procedure affecting the latent Dutch residency in the Netherlands is not an eligibility requirement for latent Dutch applicants. Applicants for Dutch citizenship through the option procedure are not required by Dutch law to renounce any foreign citizenship they might hold. However, the laws pertaining to their other citizenship may disagree. By place of birth, a child born in the Netherlands, the Dutch Antilles or Aruba to at least one resident foreign national parent is a Dutch subject if at least one of the parents was born in the Netherlands, the Dutch Antilles or Aruba to a resident foreign national parent. A child found on Dutch territory, whose parents are unknown, is considered Dutch by birth if within 5 years since being found it does not become apparent apparent that the child had another citizenship by birth. By naturalization, an application for Dutch citizenship by naturalization must meet all the conditions below: aged 18 or over, holder of a permanent resident permit or a valid residence permit with a non-temporary reason of stay, 5 years of continuous residence in the Netherlands, Aruba, Curaçao, or Sint Maarten with a valid residence permit prior to the application date. Residency under a temporary reason of stay is also counted in those 5 years. There are a number of exceptions to this rule, sufficiently integrated in Dutch society and are able to read, write, speak and understand Dutch. This must normally be proved by taking a naturalization test. Successful completion of an eligible integration course is an alternative. The Staatsexamen Nederlands als tweetaal diplomas NT2I or NT2II give the holder exemption from taking the naturalization test. There are lots of other exemptions. See the decision naturalization test Art. 3. In the 4 years preceding the application, the applicant has not been given any custodial sentence, training order, community service order, a high monetary penalty. Since the 1st of March 2009, anyone who requests naturalization must take an oath promising adherence to the values of the Dutch state. I swear that I respect the constitutional order of the Kingdom of the Netherlands, its freedoms and its rights, and I swear to faithfully fulfill the obligations due to my nationality. So help me God Almighty, or this is what I promise and declare. Quote, according to Art. 23.3 of the Kingdom Act on the Netherlands Nationality, some categories of people are accepted from declaring their allegiance through a general administrative measure. According to Art. 68.6 of the Decree regarding the obtention and loss of the Netherlands nationality, persons with a physical or psychical handicap who are unable to state their allegiance are exempted from doing so. Exemptions to the residence requirement. The 5-year residence requirement may not apply where the applicant falls into any of the following categories: a person adopted after majority in the Netherlands, Aruba, Curaçao, or Sint Maarten by parents at least one of whom has Dutch nationality, married to or of the registered partner of a Dutch man or woman. If this is the case, the person can submit an application for naturalization after 3 years of marriage, a registered partnership and cohabitation. If the person has cohabited in the Netherlands with a Dutch man or woman for an uninterrupted period of 3 years, an application may also be submitted. Note: this is true in respect to marriage, partnership or cohabitation if and only if in the last 3 years the applicant has continually lived together with the partner inside the Netherlands. In case of marriage, it does not matter where this happened. As a rule of thumb, for each past year, more than 6 months per year must have been spent under the same roof with that partner. There is an extra clause, namely that the couple has to remain living under the same roof for as long as the request for naturalization is being researched. The 5-year term is reduced to a 3-year term if the applicant is stateless. The 5-year term is reduced to a 3-year term if the applicant as a minor is acknowledged and legitimized by a Dutch national and has been cared for and brought up by this Dutch national for a period of 3 years. The 5-year term is reduced to a 2-year term if the applicant has legally lived in the Netherlands, Aruba, Curaçao, or Sint Maarten for a period of 10 years, the last 2 of which are uninterruptedly a former Dutch subject. In some cases the applicant will instead be able to use the option procedure. Exemptions to the requirement to renounce foreign citizenship. An applicant for naturalization does not have to give up his current nationality in the following cases: where the original nationality is automatically lost upon naturalization as a Dutch subject. The legislation of the applicant's country does not allow renunciation of nationality. The person is married to or the registered partner of a Dutch national. Recognized refugees, born in the Netherlands, Aruba, Curaçao, or Sint Maarten, and still living there at the time of application, where the person has lived in the Netherlands, Aruba, Curaçao, or Sint Maarten for an uninterrupted period of 5 years or longer before age 18, where the applicant cannot be expected to contact the authorities in the country of which they are a national, where the applicant has special and objectively accessible reasons for not renouncing his existing nationality, where, in order to give up the current nationality, the applicant would have to fulfill military service obligations or pay for such military service instead of fulfilling it. This must be demonstrated in each case. Where renunciation of the applicant's existing nationality would cause serious financial losses, this must be demonstrated. Where, in order to give up the applicant's current nationality, the applicant must pay a large sum of money to the authorities in his or her country. These exemptions do not hold for citizens or subjects of Austria, Denmark and Norway, since these countries signed and ratified without reservations and never denounced the Convention on the Reduction of Cases of Multiple Nationality and on military obligations in cases of multiple nationality. This was also the case for Belgian subjects until the 28th of April 2008, since Belgium denounced Chapter 1 of this treaty on such date. In a similar way, this was also the case for Luxembourgian subjects until the 10th of July 2009. Children aged under 18 may be added to a parent's application for Dutch citizenship. Those aged 16 and 17 will only be naturalized if they give their active consent, while those aged 12 through 15 inclusive are given a chance to object. By resumption, former Dutch subjects who hold permanent resident permits and have resided in the Kingdom of the Netherlands for at least 1 year may regain Dutch citizenship through the option procedure. Where the person is not resident in the Kingdom of the Netherlands, the person must have lost Dutch citizenship after reaching the age of majority and through the acquisition of another citizenship. In addition, one of the following conditions must be satisfied: born in the country whose nationality was acquired and living there at the time of acquisition of the nationality of the country, or, before turning 18, lived in the country whose nationality was acquired for an uninterrupted period of at least 5 years, or, at the time of acquisition of the nationality of the other country, the person was married to someone who possessed that nationality. These criteria are similar to the criteria for exemption from loss of Dutch citizenship in place since the 1st of April 2003. If a former Dutch national lost Dutch nationality prior to the 31st of March 2003 under one of the 3 conditions above, that individual may submit an application to regain Dutch nationality through option. The application opting for Dutch nationality may be submitted up to the 31st of March 2013. Loss of Dutch citizenship. Dutch subjects may lose the citizenship through long residence outside the Netherlands while having more than one nationality, or acquisition of a foreign nationality. In addition, in some cases it is possible to be deprived of Dutch citizenship by residence outside the Netherlands. The Dutch law has contained for many years provisions that removed Dutch citizenship from certain Dutch persons who held another nationality at birth and remained resident outside the Netherlands in adulthood. Before the 1st of January 1985, Dutch subjects lost the nationality in cases where they were born outside the Kingdom of the Netherlands, lived for an uninterrupted period of 10 years outside the Kingdom after reaching the age of majority, and did not submit notification that they wished to retain the Dutch nationality before the period of 10 years. These provisions affected Dutch subjects born abroad before the 1st of January 1954. Under the 1985 legislation, Dutch subjects born outside the Netherlands who also held the nationality of the country of the birth lost Dutch citizenship if they lived in the country of the birth for 10 years after they turn 18. Those who were issued a Dutch passport or proof of Dutch citizenship on or after the 1st of January 1990 are deemed never to have lost Dutch citizenship. This exemption was put in place on the 1st of February 2001. Former subjects who were not issued a Dutch passport or proof of Dutch citizenship in 1990 later were given a limited period of time to acquire Dutch citizenship by option, until the 31st of March 2005. Since the 1st of April 2003, following an amendment to the Netherlands Nationality Act of 1985, Dutch subjects with dual nationality will lose their Dutch citizenship if they hold a foreign citizenship and reside outside the Kingdom of the Netherlands of the European Union for 10 years. In the case of Dutch subjects who possessed dual nationality on the 1st of April 2003 and who were then resident outside the Kingdom of the Netherlands and the European Union, the 10 years started on the 1st of April 2003. The amendment lets Dutch subjects who hold foreign citizenship and reside abroad keep the citizenship by either having a principal residence in the Netherlands or another EU member state for at least a year, or applying for a Dutch passport or proof of Dutch nationality before the 1st of April 2013, the end of the 10 years. A new period of 10 years starts on the day that the person is issued with a passport or proof of Dutch nationality. By acquisition of another citizenship, a person over the age of majority who voluntarily acquired another citizenship before the 1st of April 2003 automatically lost Dutch citizenship. For the 1st of April 2003, loss of Dutch citizenship upon naturalization in another country is still automatic unless at least one of the following exemptions applies. The person is born in the country of the other nationality and has a principal residence there at the time of acquisition of the nationality. If before turning 18, the person has had a principal residence in the country of the other nationality for an uninterrupted period of 5 years. If the person is married to a living person who possesses the nationality that the former person wishes to acquire. If a person already lost Dutch nationality under these three exceptions prior to the 1st of April 2003, the final date to regain Dutch nationality under these three exceptions was the 1st of April 2013. Since then, it is no longer to reacquire Dutch nationality by option under these three exceptions if the person had already lost Dutch nationality prior to 1 April 2003. The only way to regain Dutch nationality is by naturalization. These exemptions do not apply in the case of acquisition of Austrian, Norwegian or Danish citizenship before 28 April 2008. Those exemptions did not apply to obtaining Belgian nationality before 10 July 2009. These exemptions did not apply to getting the Luxembourgian nationality. This is due to the provisions of the Convention on the Reduction of Cases of Multiple Nationality, to which the Netherlands became party in 1985. Other exceptions also exist, such as the one in which minors who naturalize independently from their parents will not lose their Dutch citizenship. That was particularly helpful prior to 1985, when the age of majority was 21. The exemptions lead to internal problems in the case of acquisition of Japanese or South Korean citizenship, since neither Japan nor South Korea allows its nationals to hold foreign citizenships in their adult years. Of course, they are strictly Japanese South Korean internal affairs and have to be solved by Japanese South Korean citizens themselves, according to the laws of their own country. They are not problems of the Dutch state, and all that the Dutch laws say in this respect is that such Dutch subjects with dual nationality are allowed to renounce to their Dutch nationality. Dutch subjects are not allowed to renounce the nationality if they become stateless, so this renunciation has to occur while they have dual nationality, which is illegal in Japan and South Korea. Therefore, acquiring Japanese or South Korean nationality cannot be done by exempted Dutch subjects without breaking the laws of such countries. Each sovereign state decides for itself who are its citizens, and other states are not allowed to bother with such internal affairs. By deprivation, Dutch citizenship by naturalization may be withdrawn if procured by fraud, or if the naturalized Dutch subject does not renounce a foreign citizenship as per the requirements for naturalization. A similar requirement exists for citizens of Japan and South Korea. Dutch citizenship may also be revoked in the case of service in a foreign army at war with the Netherlands. The possibility to reapply for lost Dutch nationality under those three exceptions expired on the 31st of March 2013. By joining jihadist groups. On the 29th of August 2014, Dutch ministers, in their effort to discourage young Dutch Muslims from joining terrorist organizations involved in a war with the Netherlands or one of its allies, plan to increase the options of withdrawing Dutch citizenship from dual nationals. This will be extended to the people who train in terrorist camps, work in them as instructors. In addition, passports of people suspected of making plans to travel to a conflict zone and join a terrorist organization like ISIL may be declared invalid. Visa-free travel. Visa requirements for Dutch citizens are administrative entry restrictions by the authorities of other states placed on citizens of the Netherlands. In 2014, Dutch citizens had visa-free visa on arrival access to 172 countries and territories, ranking the Dutch passport third in the world according to the Visa Restrictions Index. Dual citizenship. Although Dutch law restricts dual citizenship, it is possible for Dutch subjects to legally hold dual citizenship in a number of circumstances, including those who acquire another citizenship at the time of birth, persons who acquire Dutch citizenship through the option procedure, persons who become naturalized Dutch subjects if they obtain an exemption from the requirement to renounce the foreign citizenship, such as those who are married to Dutch subjects who naturalize in another country who are exempted from the loss of nationality rule, such as those married to a citizen or subject of that country. Dispute. Dutch nationality law is an object of enduring dispute, dissension and debate, since the electoral campaign of Pim Fortuyn turned immigration into a hot issue in Dutch politics. Since the assassination of Pim Fortuyn, anti-immigration politicians like Geert Wilders and Rita Verdonk have opposed dual citizenship of the European Union, because the Netherlands forms part of the European Union. Dutch citizens are also citizens of the European Union and thus enjoy rights of free movement and have the right to vote in elections for the European Parliament. Former territories. Before independence, Dutch citizenship was held by many persons in Suriname and Indonesia. In general, those acquiring citizenship of these countries at independence have lost their Dutch citizenship, but a request for determination of citizenship status can be addressed to the Dutch authorities. Dutch citizenship statistics. Figures from the Dutch government show that approximately 11,500 people were granted Dutch citizenship by naturalization in the first 6 months of 2003. There were close to 20,000 applications. According to the country's statistics office, nearly 21,000 people were granted Dutch nationality through naturalization in 2004. This is 4,000 fewer than in 2003 and half the number in 2002.